Welcome to the Palace Letters and the Right to Public Access to Records hosted by the Australian Society of Archivists. I want to start by acknowledging that though we're meeting virtually today, we've got people joining us from the lands of many peoples around the country. I myself am on the lands of the Ngunnawal and Ngambri people, and I acknowledge the traditional owners and pay my respects to elders past and present. I also want to extend those respects to the traditional owners of lands across this continent and welcome any Aboriginal and Torres Strait Islander peoples joining us today. I'd like to start, before we get into our discussion, with a little bit of background to give a bit of history of what we're talking about today. So the events culminating in the dismissal of Labor Prime Minister Gough Whitlam from office on 11th of November 1975 are considered by some the greatest political and constitutional crisis in Australian history. And a central figure in that story is Sir John Kerr, the Governor-General of the time. As Jenny Hocking writes in her book, The Dismissal Dossier, there's no single episode in our political history that's been as thoroughly traversed as this. And despite this, Hocking claims that history was never really settled. She's written of recent archival revelations which have recast our understanding of the dismissal, but some key archival documents remain unseen by researchers. And chief amongst these are the so-called Palace Letters. So it's 211 items of correspondence between Queen Elizabeth, Sir Martin Charteris, who was a private secretary from 1972 to 1977, and John Kerr. We don't know what these letters hold. The information they contain may be incendiary, revealing, mundane. It might be a combination of all three. On screen now, you can see some letters between Kerr and Buckingham Palace from other files which have been accessible, and thanks to Anne Twomey for providing these images. For example, there's a handwritten message from Charteris to Kerr which includes the following. It was of course fascinating to hear more of the inside story of the events leading to 11th of November from your own lips. Would have been interesting being a fly on the wall at that lunch. Another letter written by Kerr in 1978 refers to his book and includes the intriguing line, I did my very best, of course, to omit any reference to the exchanges between Martin Charteris and myself. Our subject today isn't the events of 1975, but the story of these records and the implications for archives and their users. So what are the records themselves? The Director General of the National Archives of Australia, David Fricker, has described how the Palace Letters were deposited by Sir David Smith as Sir John Kerr's agent with the Australian Archives in August 1978. Kerr's instructions were that the records would be released 60 years from the end of Kerr's appointment, quote, only after consultation with the Sovereign's private secretary of the day and with the Governor-General's official secretary of the day. These records were treated as personal rather than as Commonwealth records, and that meant, for example, that the open access periods for records outlined in the subsequent Archives Act of 1983 did not apply. So biographer and political historian Jenny Hocking disagreed with this assessment that these were personal records. In September 2016, she launched legal action in the federal court, arguing the letters between the Queen and her representatives and the Governor-General were the property of the Commonwealth and not of Sir John Kerr and his family. In March 2018, the federal court handed down its judgment. While the public interest in the letters was clear, quote, in providing periodic briefings to the Queen, Sir John Kerr was not exercising the executive power of the Commonwealth under Section 61 of the Constitution. As the National Archives noted at the time, the personal records of Sir John Kerr will remain subject to the conditions set out in the instrument of deposit. So it's perhaps not that simple. At some point in 1991, when the National Archives under George Nichols agreed to change the access conditions, the period of time in which they would remain closed went from 60 years down to 50 years. And rather than just consultation with the Sovereign's private secretary and the official secretary to the Governor-General, access would require their approval. It was referred to by Twomey in a recent article as a veto. Does this contradict the idea that these were the personal records of Kerr, or that the conditions of deposit should remain or did remain inviolable? So Hocking, encouraged in part by a dissenting judgment from Justice Flick that it would be, quote, difficult to conceive of documents which are more clearly Commonwealth records, took the case to the High Court. And last month, they ruled 6-1 that the Palace Letters were Commonwealth records under the Archives Act. Contrary to some media reports, the court didn't say that they must now be accessible, only compelling the National Archives to reconsider Professor Hocking's request for access to the deposited correspondence. So they're now being reviewed as Commonwealth records, and the National Archives has said it will decide on access in 90 days. It remains to be seen how many of the letters are released and what their contents reveals that we don't already know, if anything. It will also be interesting to see how many letters, if any, remain closed or redacted, and if so, on what grounds. But regardless, many archivists, historians, researchers, journalists, and others are going to be watching this case with a lot of interest. So there are lots of issues raised by all of this, too many to cover in a single webinar. What responsibilities do archives and archivists have to their donors and to legislative and record-keeping requirements? And how do they balance these with the needs of users and the general public, particularly when access to records is deemed to be in the public interest? Who does archival legislation support? How well do current access regimes around the country support researchers and other users? And what are the impacts of broader issues here, like long-term review periods, ongoing funding cuts, proposed mergers? What's the impact of all this on access to public records? So before introducing our panel discussion, I first want to welcome David Fricker, who I think we now have online, to say a few words on behalf of the National Archives of Australia. So David's Director General of the National Archives, a position he's held since 2012. In 2014, he became President of the International Council on Archives, and in 2015 was appointed by the Director General of UNESCO to the position of Vice President of the UNESCO Memory of the World International Advisory Committee. Welcome, David.
Thank you very much, Mike. Thank you. Now, I have the usual webinar question. Can you see me and can you hear me?
Yes, we can. Thank you very much for taking some time out. So could you tell us a bit about the Palace Letters case and the implications of the High Court decision for the National Archives?
Yeah, look, I will. Thanks, Mike. And thank you, ASA, for hosting this webinar. And I think you've got a great panel about to talk about it all on a matter which I think is quite important for archives, for the National Archives of Australia, but I think for archivists as a profession, you know, and what are we doing as a profession, and what's the right thing to do, and what's the lawful thing that we're doing. So look, the case of the Palace Letters, I guess it starts around, you know, when the Archives Act itself is enacted back in 1983, and the rather interesting construct written into the Act about the way that the Governor-General is described in the legislation as a Commonwealth institution. It is the official establishment of the Governor-General, which is considered to be the Commonwealth institution, not records of the Governor-General. So the Governor-General, the office of the Governor-General was not defined as a Commonwealth institution. And the other thing is that the Archives Act was premised on not provenance, but property. And so whether or not a record was considered to be a Commonwealth record, and therefore open to the scrutiny of the public through the provisions of the Archives Act, that definition turned on property, you know, the idea of whose property was a record. And this was commented on at the time. You know, R.G. Neil, who's my predecessor back then, you know, gave evidence to this at the Senate when the legislation was being drafted and discussed. You know, some of the implications of having a property-based rather than a provenance-based definition of a Commonwealth record. So it started with that, and the way that these particular items of correspondence were treated in the Act. And look, you mentioned a few things in your introduction there, Mike, about, you know, what sort of caveats were given to the archives when the records were deposited, the subsequent reduction of the open period, which was on the advice of the official secretary and with the agreement of Buckingham Palace. And Twomey, you've also, Anne, raised this as being something that would indicate these records were always under the control of the Queen versus the depositor. But look, let me just, I suppose, cut to my position throughout the course of this, that the National Archives of Australia is Australia's archive. We are entrusted with the preservation of the records of the Commonwealth, the memory of the Commonwealth. And as an institution, as opposed to a sort of a policy department of the government or a normal sort of department of state, as a national institution, you know, we have to adhere to a code of ethics, but we also have to do things according to law. So we are always required to be doing things according to law. What is the lawful thing to do? And then over and above that, what is the right thing to do? Now, these records that are given to us, the prevailing view And this has been the view that's been given to us by appeals tribunals, by federal courts, over, up until the High Court decision. I'll get to that obviously in a moment. But the prevailing view was that these items of correspondence between the Governor-General and the monarch were not records of the official establishment, because they were sort of private correspondence. These were not proclamations made by the Governor-General. They were not his exercise over with the Executive Council, or these sorts of issuing of awards or enactments of legislation. These were not sort of products of the official establishment. These were documents that he had, which went to his private machinations, the way his deliberative processes, etc. And so that was the prevailing view. And so our responsibility as the archives was to make sure that we're operating according to law. And the prevailing legal opinion at the time, and this was supported by tribunals and by the federal court, certainly by the federal court and then the full bench of the federal court, were that these were personal records. So the National Archives is therefore compelled to treat them as personal records, non-Commonwealth records. So then what is the right thing to do? What is the ethical responsibility of an archivist who has been entrusted with the personal records of an individual, on the condition that these records should not be released until a certain date, and thereafter only with the agreement of the Sovereign and the Official Secretary of the Governor-General. These are the wishes given to us by the depositor, not by the Queen, not by anybody else, by the depositor. And so they're personal records given to us in trust with these conditions. And so they were faithfully treated that way. And they've been preserved because they are of intense public interest. They're very, very important to the history of Australia. They're a turning point in Australia's constitutional history. That has never been in dispute. With Jenny Hocking or many of the other researchers, I mean, the archives has worked together with Jenny on, we've co-funded projects with Jenny Hocking. This has never been about me against Jenny Hocking. It's always been about, well, what's the correct thing for us to do? And so after the death of Sir John Kerr, we still are operating in trust with, what is the right thing to do. So when the opportunity is presented through the parties to those, or through the parties mentioned in Sir John's wishes to us, when the advice comes through from Government House and Buckingham Palace that, well, look, as far as we're all concerned, this stuff can be released 10 years sooner, then it wasn't me, it was George Nichols, as you say, but the person in my position, the position I currently hold, has got to say, well, what's the right thing to do here? Should I say, no, I disagree. No, Sir John would never have wanted that. We have to remain absolutely true to what he said and maintain that initial thing. Or would you say, well, no, Sir John deposited these because he had an eye on history. Sir John Kerr always wanted these things to be published one day. That was never in dispute. And here's the opportunity, with the agreement of all parties, to the best of our judgment, that this should be released perhaps 10 years sooner to the Australian public. And so that decision to renew that release period was not, and I say this, and I know Anne will talk about this later, but it was not as a sign of, blind deference to Her Majesty. It was, here's an opportunity to comply with the wishes of the depositor, still dealing with these as personal records. Here's a way, and as an archivist, to say, well, here's a way that we can have these records accessible that much sooner. So I do think it's fair for the National Archivist of the day to apply, it's lawful to do this, and therefore what's the ethical choice? So having established that it is lawful to do this, then he said, well, what should I be doing as the National Archivist Australia? Should I keep this stuff secret for longer, or should I make it public sooner? Of course, he decided to make it public sooner. And I think that was commented on in passing by the High Court judgment as saying, they agreed, this was the correct course of action to take. So that was that. And so it's always been about, how do we maintain trust as a national institution, so depositors in the future can trust us with their records, but at the same time, always operating according to law. And finally, I just think, that's why we've welcomed this judgment of the High Court. And we are now flat out working towards releasing these things. And Mike, I will finish because I know you want me to shut up, but I promise I will now. But look, there's a bit of debate out there still about, is this, 90 days? Will the archives, take 90 days? Honestly, I've stopped reading the legislation now. I'm very happy to no longer be in any sort of legal dispute with anyone. All I'm focused on is not any particular deadline. I'm not working towards any particular deadline other than to release the letters. The only thing people care about now is, what do those letters say? And that's what I'm interested in producing for the Australian public as soon as I possibly can. So maybe I'll finish it there unless there's any last minute questions, but by way of introduction, that's perhaps where I should leave it so I can let the discussion start.
That's fantastic. And thank you very much for your time, David. We appreciate your thoughts. And as you say, I'm sure many of us are looking forward to seeing the contents of these letters and seeing what they hold. I'm now going to introduce our panel for the discussion in the webinar. So we have three fantastic guests joining us today. We have Professor Anne Twomey. So Anne has practiced as a solicitor and is admitted to practice in New South Wales, Victoria, the ACT and the High Court, but doesn't hold a current practicing certificate. She's worked for the High Court of Australia, the Commonwealth Parliamentary Research Service, the Commonwealth Senate and the Cabinet Office of New South Wales, as well as acting as a consultant to various government bodies. She's currently Professor of Constitutional Law and Director of the Constitutional Reform Unit at the University of Sydney. Welcome, Anne. Adrian Cunningham is also joining us. Adrian has worked for 36 years in collecting archives, government archives, including the National Archives of Australia and the Queensland State Archives, and in university settings and research projects. During that time, his work traversed almost all functional areas of archival endeavour, with his latter-day focus being on digital record keeping and digital archiving. And he's now an independent consultant and remains active on various committees. Welcome, Adrian. Hello. And we also have Bridget Griffen-Foley. Bridget is a Professor of Media at Macquarie University, where she founded the Centre for Media History in 2007. She's the author of 4 books, including Party Games, Australian Politicians and the Media from War to Dismissal from 2003, and edited a companion to the Australian Media in 2014. Bridget is a Fellow of the Australian Academy of the Humanities and serves on the editorial board of the Australian Dictionary of Biography. And I'm the moderator for the discussion, Mike Jones. I'm an archivist, historian and collections consultant based at the Australian National University in Canberra in the School of History, and I'm also a councillor for the Australian Society of Archivists. So, welcome all, and thank you very much for making the time to discuss this really interesting case that's been in the media recently. We've had articles in the papers, we've had Jenny Hocking speaking about this case, we've had articles from David Fricker, and we've just heard from David Fricker in the introduction to this webinar. I want to start by asking about the significance of this case, and I'll start with you, Anne. From a legal perspective, why is this case so significant?
Well, from a legal side, as you know, probably not hugely significant. Mostly it's a matter of statutory interpretation. From a constitutional side, however, it's actually really important that we understand how our constitutional system works. Now, most of it works above the surface. You can see the rules, you can read the Constitution, you can see the cases. But the bit that's hidden, the bit that we don't really understand, is particularly the relationship between the Governor-General and the Prime Minister on the one hand, and the Governor-General and the Queen on the other. Now, that is much more difficult to understand, and the secrecy side of things makes it much more difficult. And, you know, a 30-year rule, or now down to a 20-year rule in some cases, is fine. You know, I'm not one of those people that wants everything out there immediately. I've worked in government. I know that's just not feasible. But if after that 20 years or so, you can see how in practice the system works, you can then make a bit of a judgment as to how it's working now. The problem that we have is if you say, well, you can't see things that are 50, 60, 70 years old when you've got a very long-lived monarch, that means it's really difficult to know how the system actually is working now if the only precedents you've got are from, you know, George VI and George V, which was a very different world when the constitutional system would have worked really differently. So we're just blind without that. And that's why having access to this sort of correspondence is actually really important from the point of view of understanding our constitutional history, which helps us understand how our constitution works now, and that's the really important thing.
Thank you, that's fascinating. I also want to think about this from an archival perspective, and David in his introductory video talked about some of the big questions for archivists here. So Adrian, what do you see as the significance of this case and this High Court decision from an archival perspective?
Yeah, well, look, the first thing I would say is this is the first time that I'm aware that the highest court in the land has examined issues to do with archival legislation. So, you know, from an archivist perspective, that's terribly exciting that our legislation and the way archives do their job is of sufficient importance that it warrants the attention of the High Court of Australia. The particular significance of this to me, though, is it helps clarify interpretation of what's hitherto been a very ambiguous part of the Archives Act. David Fricker alluded to the fact that the definition of Commonwealth record in the Archives Act is a property-based definition, and in practice that has made it quite difficult in a lot of cases to determine what is and what is not a Commonwealth record. And the fact that so many jurists over so many years have taken different positions on this question has highlighted that ambiguity. So it's great now to have some solid case law coming from the highest court in the land that helps us interpret that somewhat weird property-based definition of Commonwealth record. And I should say for anyone who's wondering, that the property basis of that definition is unique within Australia. No other jurisdiction within Australia has taken that path. The much more common approach to defining public records in other jurisdictions has been for the legislation to say a public record is any record created or received by a public authority in the course of pursuing their official business. So under those definitions, it's much less ambiguous. I welcome the fact that the High Court has provided us with some clarity in the case of the Commonwealth definition. However, I think there's still some ambiguity that lingers in the wake of the High Court decision. I'd like to explore some of that with Anne during this webinar. But ultimately, actually, I would prefer to see the legislation changed and to have that property-based definition removed entirely and replaced with something that's much clearer and easier to interpret.
Yeah, and I think we'll get certainly to some of those potential broader implications and what are some of the findings in this High Court decision that might lead to some of those changes or potentially could lead to some of those changes. Before we do that, I wanted to ask you, Bridget, as a long-term user of the archives, what strikes you about this case and the media coverage that it's produced, and what does it tell us about the importance and the significance of public records from a social and cultural perspective?
Well, this case has received a good deal of media coverage. My various devices beeped with notifications a few weeks ago when the High Court verdict or decision came down. The events of 1975 are singularly significant in terms of our political and constitutional history, and there is still more to find out about what happened during those crucial months. And as various events unfold, such as the death of Gough Whitlam, there are sort of opportunities again for an upsurge in interest in the events of 1975. I think we're a few years away from the 50th anniversary of the dismissal, so we can expect more in the next few years from Jenny Hocking and others in the lead up to 2025. I also think the fact that we're, discussing the palace letters and we've called the webinar this, really speaks to something of a sort of nascent Republican sentiment in Australia, that this case can, in the public's mind, I think, be reduced to being about the Queen versus the people, both in terms of what happened in 1975 and the role of the Governor-General, and also this sort of sense, I think, that the Queen and the Palace have been playing something of a role in denying Australian scholars and the Australian people access to information about what happened to our popularly elected government in 1975.
So that idea of the sort of connection to a Republican movement suggests, you know, some potentially really broad contexts in which this case sits. It's far from a kind of isolated event. So what precedent does this case set? You know, starting perhaps with you, Anne, you were talking about the constitutional significance of this. Does this function as some sort of precedent that's going to have broader implications?
Well, as you said, from a legal point of view, it mainly has implications for the National Archives because it has that really weird definition, which is property-based. So from that point of view, it's really only confined to the issues concerning that. Seems to me in practice that what they really did was effectively turn the property-based definition into a provenance type of definition. I mean, the two have effectively merged. So, you know, from that point of view, not, you know, obviously really important for archives and how the National Archives is run, but probably doesn't have broader ramifications. There are broader ramifications, however, in terms of letting out this kind of material. If you're talking about Republic stuff, one of the interesting comparisons is in the United Kingdom with what is known as the Black Spider letters. So these were letters that Prince Charles wrote to ministers in the United Kingdom lobbying them. Now, the Guardian newspaper sought access to those under Freedom of Information legislation. Under that legislation, they should have got access to them. They were denied access to them. Appealed to a court. The court said yes. The court rejected this notion that such correspondence had to be secret because of conventions and all those sorts of things that were again argued in Australia in the Hocking case. So in the UK, the courts rejected all of that. And then the Attorney General in the UK put out a certificate of veto against releasing the documents, saying if they were released, they would, you know, threaten the ability of Charles to be king because, you know, it would undermine his political independence, et cetera, et cetera. And so everyone thought, wow, there must be something sensational in this stuff. Goes all the way up to the UK Supreme Court, and the UK Supreme Court says you have to let the letters out. Again, the courts did not, you know, follow what the Palace was after. The courts defied the Palace at the highest court in the land, as indeed in Australia. But here's the remarkable thing. When the documents were released, they were completely and utterly uninteresting because all they said were the same things that Prince Charles had been saying in speeches for donkey's years. The Guardian, which had sold numerous newspapers on the basis of the controversy, then discovered that once it had finally won, it was a complete and utter damp squib. There was nothing in there of any excitement at all. So my suspicion is that we might be in the same territory in relation to the Palace letters. Yes, it'll be interesting to see what Sir John Kerr was saying in a contemporaneous way as things happened over time. You remove the whole gloss of hindsight and self-justification. Instead, it's a man who's agonising as he's facing decisions, looking at here are all the different possibilities, here are the things I might have to do, I'm not sure, that sort of stuff. That'll be really interesting. What comes back from the Palace? Probably, if you just look at it on the basis of all the other stuff I've seen of theirs, fairly non-committal. They'll be offering support, saying, oh dear, poor you, we know it's very stressful, offering sort of solicitude, that sort of thing. Really unlikely, however, that they're telling him what to do or giving him green lights and all this sort of business that's been suggested. Will it do much for the Republican movement? Maybe not a lot, in the same way that the Prince Charles letters did not, despite the Attorney General's certificate, prevent him from, you know, being king by destroying his political neutrality. So my suspicion, solely based on other letters that I've seen from that era, is it's probably not going to be as exciting as expected. It's probably not going to have a huge sort of leap for the, you know, the Republican side. But, you know, you never know. Could be surprising. I mean, that letter I gave you, which showed the line that said, you know, and I tried hard not to mention the correspondence with Sir Martin Charteris. That suggests maybe there's something good there. The other key thing to note, by the way, is just that the Queen herself never writes the letters. Okay, so although there'll be mention of the Queen, none of the correspondence will be from her directly. So you'll never see what she says personally. You'll only ever see what her private secretary says. And then you can never know precisely whether it's just his personal view or whether it's hers. And that gives that plausible deniability. So that will definitely be in there as well. So Martin Charteris, by the way, is, if you read all these letters, and I've read a lot of them, is a lovely chap. He's charming, he's funny, he's witty, his correspondence is amusing. So, yeah, it'd be quite interesting to see what he says. And he might say a few indiscreet things because he was a bit more indiscreet than some of her later private secretaries. But, yeah, from a precedent point of view, yeah, it should, and this is interesting thing, it should also result in opening up other letters from Governors General and their correspondence with the Queen. So if we could also see in their context the letters with Lord Casey, the letters with Sir Paul Hasluck, Sir Zelman Cowen, Sir Ninian Stephen, all of those letters which are now in the open access period, for someone like me, that'd be great. I mean, going beyond the dismissal to looking at all the other things that arise, you know, Holt's death and all that sort of stuff. I think it'll be fascinating. I'm really looking forward to it, but I hope we actually do get to see them and not a whole lot of redacted, blacked out stuff.
Yeah, absolutely. So Adrian, as someone who's worked in archives for many years, do you see this as that sort of precedent? Do you see this as something which, if you were working in that space, would be telling you that you should be opening up that other correspondence, or would you see this as a really focused judgment that doesn't have those sort of broader implications? Is this just about reviewing the 211 palace letters, or is it bigger than that?
Well, it's certainly bigger than that, and I agree with Anne that the precedent would clearly apply to all viceregal correspondence of that kind. What's less clear to me from the judgment, and Anne may be able to enlighten us on this, is to what extent does the precedent extend to all other records of individuals who've had associations with the Commonwealth, who have subsequently claimed that they're, you know, what records that the average person might regard as being official records, they've then claimed to be their personal property. And there have been numerous examples of uncertainty bedeviling access requests for all sorts of records of former prime ministers and former Commonwealth officials, etc. I'd like to think that this judgment provides some clarity on interpretation for those matters, but I'm not a lawyer, so I don't know, and I would be interested to hear Anne's view on that. But if it does, then that's a very good thing. But look, the other issue of this case that intrigues me is it still begs the question of, well, what are the limits of Australian sovereignty? One of the High Court judges was of the view that the Governor General sits outside the Commonwealth. Now, fortunately, you know, I'm personally glad that that view didn't hold sway, but it was interesting to me that one High Court judge felt that. And if that view had in fact been the majority view, I think it would have really turbocharged Republican sentiment in this country, because the view that Australia can still be ruled by people who sit outside of the Australian legal entity, if you like, would be outrageous to many Australians. There's also the question of now that they examine the letters and with the view to identifying potential access exemptions, and one of the exemptions that's often quoted is correspondence with foreign powers. Now, I wouldn't see a Governor General's correspondence with the Queen of Australia as being in that category, because the Queen of Australia is not a foreign power, even though she happens to be the Queen of other foreign countries. So I wouldn't have thought that that exemption would be legitimate in this case. But again, I would be interested in a lawyer's interpretation of that.
And do you have any thoughts on that?
Sure, I can respond to a few of those. So yes, in terms of those exemptions, again, my view, like yours, is that you couldn't say that this was communications with, you know, a head of state of a foreign power, because clearly she's being, the correspondence is in her capacity as Queen of Australia. So that's essentially a domestic relationship. But what I can tell you is that there has been other litigation using the equivalent type of exemption under the Freedom of Information Act, and that was in relation to correspondence between the Prime Minister and the Queen, and the argument was put there that that would undermine or damage international relations. Now, personally, I think this is a ludicrous argument, because I can't see that, for example, Canada is going to be affronted and take, you know, action against Australia if the correspondence between the Australian Prime Minister and the Queen of Australia is made public under an Australian law. I mean, you know, if I were Canada, I'd think, oh, good for you. You actually take your laws seriously, you know. And especially given the black spider letters in the United Kingdom. I mean, did the Supreme Court there say, oh, it might damage, you know, relations with Australia if we release the correspondence between Prince Charles and a British minister? I think it's stupid. Nonetheless, it was recently upheld as an argument by the AAT. So it's not inconceivable they'll try that one on. And if they do, my bet is that Jenny, given that she's presumably still got a bucket of money left from her crowdfunding now that she's got costs in this litigation, I reckon she'll be back in court arguing against that one, and good for her if she does. So yeah, there are all sorts of issues with the exemptions. So there's also exemptions in relation to, you know, breach of confidence stuff as well. Again, I don't think it actually does apply in the circumstances, but nonetheless, these will be things that the archives will be looking at. So the other issue was the stuff about property and the extent to which it applies to other sorts of things. I think it depends very much on the nature of the document. So what the court focused on, there are a couple of general principles. One is that they drew a distinction between who is the true owner of the document. So the true owner could have been Kerr, or the true owner could be, you know, Malcolm Fraser or someone like that. And the Commonwealth can still have property in it, because they say that property is not a binary thing. It's not like I have property, you don't. Okay, I'm the Commonwealth and I can have property in something at the same time that you are the true owner of the document. Right? Property is a bundle of rights, and so you can have rights in relation to possession of the documents, for example, and that might be enough to give you property even though someone else is the true owner. So that's the distinction that they make, although they do it in slightly more complex term. They describe it as a legally endorsed concentration of power. But effectively, that means if you've got physical control over the documents, because it's the type of document that normally would be dealt with by an official agency of the Commonwealth, so one of those Commonwealth institutions, if it would ordinarily be in their files, and if, as in this case, it was transferred from those files into the archives, then that certainly would put you into the seat of being something that's Commonwealth property. It's a bit more difficult if you took the stuff with you when you left office and it's been sitting in your, you know, boxes in your back cupboard, and then you present it to the archives. So then there's that sort of second question. Well, that's slightly different from the Kerr case. But if you look at the judgment, it does not only refer to the fact that David Smith had physical custody of the documents and he put them in as the official secretary, it also refers to, I think, I've lost my piece of paper here, but something like, it talks about the nature and the significance of the documents. And so that's got to do with the status of them and their relationship to the Commonwealth as records of, you know, Commonwealth activity. So I think one would need to look more broadly at the nature and the significance of the documents, as well as whether they're the type of document that would ordinarily be under the physical control of a public service department or one of the institutions of the Commonwealth. And if that is the case, then that should be enough to trigger it to be property of the Commonwealth. At least that's my reading of it. But there are some ambiguities, as you say.
And so just to let people know, we will be opening things up to questions in 5 or 10 minutes time. So if you do have questions, then please start putting them through. We have a couple already, but I'm going to hold off on those until we get to the start of the Q&A session. I just want to bring in Bridget again, because these discussions of the sort of intricacies of the law and the archival legislation are really fascinating to some members of the archival community and to the legal profession and to people who are really sort of down in the weeds in this sort of space. But in the media, I mean, this has been portrayed more as a battle between a researcher and the archives. The researcher says, I want these records. The archive says, no, you can't have them. And it's difficult for some people to understand what the foundations of that are. But there have also been sort of broader elements here where the National Archives is, questions around access and review periods for the National Archives. There's been things like the Tune review that many people may know about, where there were submissions about the National Archives and the way that it functions as an organisation, and then a report that was submitted to government, which we're still waiting to see publicly, but that report has been submitted to government. So I know you submitted a response to that review, and you wrote in that about the National Archives' broader struggle to fulfil its mission for a whole bunch of reasons. So as a researcher, what do you see as being that mission of the archives, and what are some of the challenges for researchers and archival institutions in the current climate that are both related to this case, but also that exist more broadly?
Well, the mission of the National Archives is really to provide Australians with access to the memory of our nation, and also to provide us with information about the actions and decisions of our government and its various agencies. The Tune review that you've referred to is delightfully, the official name is a functional and efficiency review, and I think one of the real challenges, or the fundamental challenge to the National Archives in the last decade or so has been efficiency dividend after efficiency dividend, so that we've seen the budget and headcount of the National Archives shrink significantly over that period. At the same time, more has been expected of the National Archives. The 30-year rule has dropped down to 20 years. So the National Archives, with no new funding, has been attempting to clear 2 years of records per year, so that the 30 years gradually reduces down to 20-year records becoming available for public access. And really the funding model for the National Archives has, I think, become unsustainable. And as you noted, more than 100 individuals and organisations made submissions to the Tune review. There are other fundamental challenges for the National Archives. I think Anne has may have pointed to this in her submission. Perhaps something of a tension between the needs and expectations of professional researchers and the enthusiasms of people interested in exploring their family history, also perhaps accessing family military records, etc. Another fundamental concern is records that are at risk of being lost. And I'm thinking particularly about the magnetic tape records held by the National Archives. The professional assessment seems to be that by 2025, those records could have deteriorated to such an extent that they will be obsolete. The ABC, in its submission to the Tune review, made the observation that only 16% of the national broadcasters' audiovisual records in the National Archives have been digitised. So there's a range of concerns around, I think, the sustainability of the National Archives and in fulfilling its mission. And I think it was incredibly concerning that last June, the Advisory Council of the National Archives actually released a statement indicating their concern about the National Archives no longer being able to fulfil its legislated requirements.
So, Adrian, bringing those issues together that Bridget has raised there, and some of the things from the Tune review, and putting that together with events like the Palace Letters case and some of the debate that's happened in the media, is there a reputational issue here for archives? Is there something that as archivists we need to be aware about, and that we need to do something to redress some of those reputational issues?
Yes, certainly. And yes, rightly or wrongly, the National Archives has been portrayed as the villain in the Palace Records case. I do think that a lot of the media commentary around that has been unfair. I don't believe that the National Archives could have handled this particular case any differently to the way it has. As David Fricker said before, they have to follow the law, and if the federal court judges have given a particular interpretation of the law, then as a Commonwealth agency they have no choice but to follow the law. The point that Bridget made is an accurate one, that that the archives has experienced major funding cutbacks in recent years to the point where it is hard for them to discharge their functional responsibilities and fulfil their legislative mandate. But in the area of access in particular, though, and I can say this now that I'm no longer a public servant, but I spent years working within the belly of that beast, and I can say categorically that the access system in the Commonwealth is broken, and I don't think it would matter how many resources you shoveled into that particular bottomless pit, it will remain broken. And it's kind of ironic, because the reason it's broken is actually because of misplaced good intentions. When the Archives Act was drafted back in the late 70s, early 80s, it was part of a suite of administrative reform legislation that was pushed through Parliament at that time. There was a strong recognition that you needed some kind of independent authority to guarantee access to public records, and so the legislation gave the access decisions on Commonwealth records in the open period to the archives. That is actually unusual compared to other jurisdictions in Australia. Mostly across the state and territory jurisdictions in Australia, access to public records is determined by the creating agency, not by the archives. Now you might think, oh, well, that doesn't sound very good. The Commonwealth law sounds much better. The archivist is somewhat independent, actually has the say about access rather than the creating agencies who might have something to hide. Sounds good in theory. In practice, it's failed to work, because the archives feels obliged to consult with creating agencies before doing finalising an access clearance. The creating agencies are often either reluctant to respond to that request in a timely manner, or if they do, they take a very conservative line. Huge backlogs occur, and the upshot is that the system has ground to a halt, and it's very, very difficult to get access to records. I worked for 8 years in Queensland State Archives, and it was refreshing after the frustrations in the Commonwealth. It was refreshing for me to see that in Queensland it actually worked much better, even though the agencies determine access restrictions. There are review powers within the Queensland Public Records Act which the archives was actually quite adept at using as leverage over the transferring agencies. If a transferring agency wanted to impose unreasonable access restrictions on a body of records, the archivist could say, are you sure about this? And do you realise I have the power to take this to an independent appeal body if I don't like it? And that kind of back pocket power was enough in every case that I encountered to get the agencies to see reason and to actually impose fair and reasonable access restrictions on the records that they transferred to the archives, and without any of the delays and obfuscation that occurs in the Commonwealth. So I've seen a system that works, I've seen a system that doesn't work, and I can tell you the Commonwealth system is broken and the legislation needs to be changed. And I'd like to see a recognition of that coming out of the Tune Review and all of the other discussions around this issue that have been occurring.
So that brings us, before we get onto the Q&A, to what are we going to see in the future in this space? So Anne, starting with you, where to next from here? In terms of either the implications of this, what it means from a constitutional point of view, or what it means for the National Archives. We're in this review period at the moment. We don't know what's in the letters, but where do we go from here?
Okay, well, first of all, we've got to get the letters out. Check for exemptions, be reasonable in relation to exemptions, because otherwise you'll end up back in court again. So that's the main process, and I imagine it will be done relatively quickly, unlike many other files. And I, along with many other people, have waited 7 or 8 years to get access to files, only to discover that there was actually something really good in the file, which I would have used in the book that I've already published several years ago by the time I got the file. So yeah, pretty unhappy about that. And that brings us to the question of the Tune Review itself. I mean, I have to say it's extraordinarily ironic that, given that most of the complaints to the Tune Review are about the fact that it takes so long to get the documents, this Tune Review was given to the Attorney General in January, and guess what? It's still not been released. So that sort of really tells you something, doesn't it, about the priority given to archives? And I just think that's really sad. So what needs to happen? Well, first, yes, the archives does need more funding. They can dig up funding for the War Memorial. I cannot see why they can't dig up funding for the archives. I mean, I know we're in very, very straitened financial circumstances. I do understand that, but you need the archives to be functional. It is part of Australia's history. It's really, really important. And it's not getting anywhere near the funding and support it needs. So that needs to be fixed badly. And secondly, the point that Adrian was making, the current system in terms of seeking advice from departments does not work. It can sit, particularly in DFAT, it can sit under someone's desk for 7 or 8 years, and people only find it when presumably that person retires and says, oh, look, here's this stuff on the bottom of the floor of my office that's been lying there for that long. Clearly doesn't work. You need something in the statute to fix that. Now, that is either that when the documents get moved to archives, in the beginning, they're already cleared for access, and that happens, as you say, in most other jurisdictions. That would be good. Or alternatively, like FOI, have some kind of requirement that actually you have to do something within a period of time, and have the consequence that if you don't do anything within that 90 days, then the documents are all released. Now, if you did that, it'd make people move and do something. So yeah, that really, really seriously needs to be fixed, because I can't in good faith advise students to do archival work, because I can't guarantee that they will get the documents that they need during the time of that they need to do their honours thesis or their master's thesis or even a PhD. And it's tragic, people having to go overseas to do PhDs that deal with archival stuff, just simply because the archives here are no longer fulfilling their function properly. They are seriously dysfunctional when it comes to the sort of documents that might be controversial. Now, I know people have been upset when I've talked before about Great Uncle Bert's war record and how you'll get that stuff, but you're not the other. That's not to dismiss family archivists and whatever. That's fine. I'm really glad that this stuff comes out. I'm just saying that when the archives comes up and says, hey, we release, 95% of the stuff, no problem. They're talking about one category of thing that's uncontroversial, that they're not talking about the category of thing where something is controversial and is the study of academics and other people who are trying to write broader Australian history rather than family history. So I'm not suggesting you shouldn't do the family history stuff, but I am saying that the archives is dysfunctional when it comes to the other stuff, and heaven knows it seriously needs to be fixed.
And if I can pick up the nexus between archives access laws and freedom of information laws is terribly important here. So in the Commonwealth, we actually have the worst of both worlds, because as soon as records tick over into the open period, they're no longer accessible under FOI. And because of these access problems that we've just talked about, they go from being somewhat accessible under FOI to being not accessible at all for all intents and purposes under the Archives Act. The relationship between those two laws in other jurisdictions works a lot better, I think. So again, if I hark back to the Queensland example, in Queensland, it all depends on who's got custody of the records. Once the records are in the custody of the archives, regardless of their age, their access is under the Public Records Act. So long as the records are in the custody of the agency, the access is under the Right to Information Act. So that actually is an encouragement for agencies to transfer records to the archives, because managing access then becomes the archives' problem, not their problem. So that's a good thing. But it also means you don't have records that suddenly fall into an access black hole once they tick into this open period, which is a construct that by and large doesn't exist outside of the Commonwealth. So I think we not only have to change the Commonwealth Archives Act, we also need to change the Freedom of Information Act, because you can't change one without the other. The two have to operate in tandem with each other.
Yeah,
and Bridget, I know you're looking forward to getting back to the archives yourself. What do you think should come out of this?
Look, I agree with everything said by my fellow panelists, especially Anne, in relation to what the next steps are. I do fear that the timing of the Tune review may be unfortunate. We are going into a period where the government and politicians will be talking about the massive deficit now facing the nation. Obviously, we have to see what the report of Tune has to say, and we're waiting for the Attorney General to release that and presumably make some recommendations. But perhaps if I just finish with a slightly cheeky point, in terms of pump priming the economy, we've seen the home building industry and upper middle class owners of private real estate being, offered up to $25,000 by the government. I would actually prefer to see money from the government go towards public infrastructure and something like the digitisation of our national cultural record.
Fantastic. So I'm going to move on to some questions from the audience now. So we have about officially 10 minutes left, but we may go on for another sort of 5 or 10 minutes after that if people are happy to do so. And we also have a poll which our General Manager James is going to bring up just to find out what interests people most about this particular area. So a few options there just to get some responses from attendees. And while people are answering that, I'm going to start with some of the questions we have from the audience. So there's a question we have touched on a bit already, but there was a lot in the media about this case that did put it as a kind of battle between a historian and the archives, a historian versus the archives. And as part of that, there's some image or reputational damage that might have occurred. So, what should the National Archives do in this case as part of restoring that trust, apart from getting the review of the records done as quickly as possible? Adrian, I might throw this one to you. Do you have any thoughts on what the National Archives should do in this case to restore some of that trust that might have been lost as part of this process?
Yeah, well, it needs to get its side of the story out, I guess. And David Fricker, I think, has done his level best to do that. And I noticed, he's written a couple of very interesting opinion pieces in some of the media outlets. But yeah, I think, I mean, just to give you an example of the reputational damage here. So for some years, I was the director and responsible for personal records at the National Archives, amongst other things. My wife is aware of that. So when the High Court decision was released and the National Archives was portrayed as either being obstructive or being incompetent or both, my wife is not an unintelligent person by any means. Her response to me was, "So, Adrian, are you responsible for this stuff up?" She was being blunt and somewhat ironic, and so I had to explain, no, well, it wasn't a stuff up, and in any case, it all happened back in 1978, well before my time at the National Archives. But if that's an example of the way the average person on the street has responded to the archives' role in this saga, it's not looking good for the reputation of archives. So I think there is an issue there for National Archives, but perhaps also the archival profession more generally, to patiently explain some of these the constraints and some of the realities of the issues to the broader population. And what better time than when suddenly the media focus is on us. We've got the advantage of a High Court decision, so we've got people's attention, which we don't often get. Let's take advantage of that to put our side of the story across.
And one for you. There's a question here about the issue of ownership of the letters, and one of the implications that one of the questioner has raised of this status of these records as Commonwealth records, but that's dependent on the National Archives retaining lawful custody of those records, which suggests that if the National Archives relinquishes custody of these records, then they're not Commonwealth records, potentially, and begs the question, how does that square with the High Court order? Do you have any thoughts on that?
Yeah, look, I think there's a real ambiguity in the judgment, which is not very helpful. So they try all the way along, at least this is the joint judgment at the beginning of Chief Justice Keefe, Justices Bell, Gageler and Keane, where they say, well, we don't have to decide whether or not Kerr had any personal ownership of those documents, because regardless of whether he did or he didn't, it's simply the fact that the official establishment of the Governor-General as a Commonwealth institution held property in them because it had this physical hold over the documents and they were of that particular nature and significance, etc. And they do have bits in the judgment where they say, well, if there was another owner, the other owner could, get the documents back, take them out of the archives, and then they wouldn't be Commonwealth documents anymore. And then towards the end of the judgment, they say, however, but with respect, which is, of course, the biggest insult you can give if you're a court sort of trying to insult another court. So they say, with respect to the federal court, we can't see how you could possibly have described these documents as the personal documents of the Governor-General, and clearly because, if that was the case, then the Governor-General could have gone out and, sold them at Sotheby's or destroyed them or whatever. And, no one's suggesting that that's the case. Well, if that's the case, then clearly the Governor-General was not the personal owner, couldn't take an action in detinue to get these documents back, couldn't withdraw them from the archives because they're still Commonwealth records. And it would seem that they're saying, well, actually, really, there was Commonwealth ownership of these documents, and they weren't the personal documents of the Governor-General because the Governor-General couldn't flog them off. Why put that at the end of the judgment without actually properly deciding it? I don't know. It's a bit messy. It's sort of like a throwaway line chucked in at the end. So from that point of view, yes, there are ambiguities in there in the judgment. It's not very clear. But it does suggest that the court was of the view that no, this correspondence was not the personal property of or owned by the Governor-General, because really these were the records of the nation. They can't be flogged off, they can't be destroyed, they have to be kept for the nation. I mean, that's the impression that it gives, and that's by 4 judges. But if they're going to come up with that at the end, they should have used proper reasoning to get there along the way, and they didn't. So yeah, from that point of view, not the world's clearest judgment, I'm afraid. That's the best I can do with it.
We have a question for you, Bridget, about the media commentary on this. Do you have any sense of whether that, you mentioned republicanism, have you had any sense as to whether the media commentary has followed political lines here? Has there been a conservative press that's been, promoting the right of, say, the Queen or the Palace to maintain control over this versus other perspectives in the press, or have you seen a more kind of uniform approach?
That's a really interesting question. I have to say, I haven't followed very closely the media reporting on all of this for the last 4 years since 2015. Obviously, I've maintained something of an interest in the case as a historian, but I haven't really noticed that. But I'm also going to say I'm on long service leave, and in recent weeks since the judgment, I've been attempting to have a little holiday, so I haven't really looked terribly closely at, say, the reporting of the Australian commentary on Sky News, etc., on this case.
Does anyone else have any thoughts on that? Yeah.
Could I just add in there? I mean, I did something with the Sydney Institute the other day, and a few other areas. My general impression is that both sides want the documents opened, because the more conservative side take the view that it would be really good to clear up what happened, get rid of the festering conspiracy theories, and therefore they're more than happy to let it all out there and let it be seen. So I haven't seen any real backlash in terms of people saying, no, you can't possibly let these things out.
No.
I think most people think that because everything else now is out in relation to 1975, it will just sort of, end the obsession if we can finally have everything out there, and then we can just sort of move on. So I think both right and left are, conservative and even monarchist Republican largely are okay with letting this stuff out. Although you'd probably find, I haven't gone on the monarchist website to look, but you'd probably find they were the ones more concerned just about the general principle of protecting the Queen and the Queen's neutrality. But as a general principle, I think the people on the, both sides of the dismissal, so to speak, are more than happy to just let it all out there and let it all finally be known.
So I'm going to bundle a few questions together here, and apologies to people listening if I've sort of oversimplified some of your questions in the interests of that. But we have, for example, someone who's noted that there are records related to things like East Timor in the 70s and early 80s, where a lot of the material has been redacted, despite the significance of that to our understanding of Australian history. Someone else mentions the issue of threats to national security that may exist within the National Archives in a different way to how it does at State Archives level. So these letters are being reviewed at the moment, and it's possible that some of these letters might be redacted. Who makes these sort of redaction decisions, and what are the legal and other criteria behind the choice of what's shared and what's not shared in these sort of situations? Adrian, maybe start with you.
Yeah, well, the National Archives has an army of access examiners who go through these records line by line. The access examiners, by and large, are retired former senior public servants. So they're people who know the way the bureaucracy works, and are in a position to make informed decisions. Of course, advice is also taken from the controlling agencies in terms of what they think might be exempted from access. Over the years since the Archives Act was passed in 1983, there's been an ever-growing body of internal precedent within the National Archives that is referred to in doing these redactions and deciding upon appropriate exemption categories, etc. So in a sense, you could say, oh, it's all very rigorous and it's been tested, and you know, there's a body of precedent, etc., that they rely on, which kind of sounds comforting at one level, but at another level, I think the whole thing has got so huge and complex that it, the sheer size and complexity of it actually contributes to the slowness of the process. So at one level it's reassuring. In another sense, it's a bit alarming actually, and I think it's part and parcel of the broken system that I alluded to before. But the I mean, the upside though is that there are appeal mechanisms. People who don't like the exclusions that have been determined can appeal those decisions to the Administrative Appeals Tribunal and then up through the Federal Court, etc., etc. So that's reassuring, but of course all these things take time, they take money, and as Anne has said, or Bridget, I should say, for the average historian who might be thinking of doing a PhD on something to do with Australian history, it's a sufficient discouragement to make them look elsewhere, which leaves us poorer as a nation, I think. So, so yeah, there is a system. It does have its internal logic, but overall, it doesn't work.
Yeah.
Yeah, we have, that sort of picks up on another question that we had here in the Q&A. How is the average citizen meant to be able to afford the sort of litigation that archives will undertake against applicants for access? Bridget, do you think that in some ways, despite the fact that Jenny Hocking won this case, that the level that she had to go to get this sort of decision overturned is an impediment to people using the archives and to seeking access?
Well, there's no doubt that most people who work in or want to work in the National Archives couldn't afford a case like Jenny Hocking, or wouldn't have the resources in terms of time or money, and may also not be, even though you know, the Archives Act is publicly available. There's some information on the National Archives website about how you can appeal, etc. I don't think it's hugely transparent, and it's just not feasible for most researchers, even you know, professional researchers like academics, to embark on a case like this.
Yeah, can I add to that? I mean, look, I've been frustrated many times by getting responses that are just completely daft when it comes to exemptions. I mean, so let me give you one example. Section 44 of the Constitution, disqualifying members of Parliament. People seem to think that was a bit of a surprise in the last few years. You go look at the archives, there are dozens of files on this from the 1950s, the 1960s, the 1970s, all well over 30 years old. And so I applied for them, and guess what they said? They either redacted the guts out of them, so there was nothing but administration in there, or they refused access altogether. And they said, oh, this is because it will undermine the Commonwealth's position in litigation, which is just complete rubbish, because of course the Commonwealth's, you know, opinions from 1950 clearly cannot apply now, because there have been dozens of cases since 1950 which you would now have to take into account in giving your advice. So the advice the Archives is relying on is rubbish. Now, admittedly, the Archives didn't make that up. Archives got that from the Attorney General's Department. The Attorney General's Department's telling them rubbish, okay? One way or another, it's rubbish. So the question is, well, what do you do? I know it's rubbish. I'm a lawyer. So do I take it on to the AAT or not? Well, look, even if I took the case myself in the AAT, just the mere filing fee is $900. That's before you even get started. That's to walk in the door. And then the risk is, if I won in the AAT, then the Commonwealth would take me on appeal, and they'd take me on appeal all the way up to the High Court. And what if some point I lose and I get costs against me? We're talking hundreds of thousands of dollars. It's an enormous risk. And my husband, when I was talking to him about this, said, well, apart from the cost and apart from the time, think about your blood pressure, because frankly, this will drive you up the wall. You'll get really, really angry, he said, and he was right. I mean, it is insane to bring this type of litigation, even though you know that you're right. And the archives knows this. I mean, this is what the whole system is based on. They can deny you stuff for ridiculous reasons, and 9 times out of 10, unless you're half mad or you've got someone to crowdfund you, you won't bring the litigation. And so the system is stacked against you. And the other real problem with it, of course, is in terms of bringing litigation, is that you don't get to see what's in the document that they're denying you access to on the basis of an exemption. So you've got one hand tied before your back before you go into court. They know what's there. They can argue in court about what it is that they know is there. You're arguing about whether an exemption applies to something that you've never seen, so you can't know for sure. So you're at a massive disadvantage. I have to say the other time I was really tempted to do this was when I got shafted in the United Kingdom under FOI, similar sort of thing. But in that particular occasion, I could prove that the Foreign Office was cheating, because in their cheating, they accidentally didn't cheat in relation to one of the draft letters when they were doing the exempting. So I got the actual words that were in the particular letter and the grounds of exemption in the other letter. So I could show exactly what it was that they were saying was exempt, and it clearly wasn't. And so I went on appeal. I went to the internal review or whatever, and I said, look, I can show you that this is not a valid exemption, and you've used this throughout all these documents, and it's wrong throughout all of them. And eventually the Foreign Office had to concede that they cheated, and they cheated in 200 odd documents. It wasn't just once. They cheated massively. I managed to prove that they cheated massively, and then they came up and said, oh, but it now falls under another exemption, blah, ha, ha. And, unless I went to the United Kingdom and ran litigation myself and took all the risk of costs, then there was nothing I could do. So even when you know they're cheating, you can't get them. It's quite depressing.
Yeah.
It's interesting, the brief poll that we put up earlier. So 52% of the audience, the main thing that they're interested in these sort of cases are broader issues related to things like access decisions. So it seems to be a point of interest right across large parts of the community. It's also interesting to say that we don't know what's in the Palace letters. We still don't know what's in the Palace letters. We are potentially about to find out within maybe the next 90 days, and time will tell what they reveal and how much we see there. Given the time, we should wrap it up there. So I do want to very much thank Professor Anne Twomey, Adrian Cunningham, and Professor Bridget Griffen-Foley for joining us this evening. I really appreciate your time. Thank you to David Fricker for his time earlier in the presentation, giving the National Archives perspective. And I'm sure there'll be many more debates and discussions on this topic still to come. So thank you everyone for joining us.
Bye-bye.
Thanks.
Bye-bye. Thank you, Mike.